Did you know that in most high-stake financial crime cases, it's not the documents that sink you, it's the insiders who turn witness against you. If you are a business owner, CXO, or legal advisor, listen closely. The greatest threat to your defense strategy may be sitting in your own boardroom. Hello and welcome to this new episode of White Collar Crime Legal Series. This is Dr. Arjun Chowdhury, advocate, and today I'll share legally sound, ethically aligned strategies to prevent your employees from turning hostile or becoming prosecution witnesses against you in a white collar crime investigation, especially under laws like the PMLA, Companies Act, and FEMA. Let's be clear. In any ED or CBI probe, Section 164 CRPC statements incriminating the promoters or directors often rely on employee testimony. If your accountant, assistant, or director becomes approver or star witness, the prosecution's case strengthens even before the trial. The risk becomes higher under PMLA, where statements under Section 50 are admissible. Income Tax Act, SEBI, or Companies Act violations, Benami Transactions Act, etc. etc. But here's the truth. It's not illegal to ensure employee loyalty and silence as long as it is done ethically and legally. So these are the preventive legal measures you must take while hiring employees in your company. Enter into a strong non-disclosure agreement. Every senior or sensitive role employee should be under a robust NDA covering confidential financial and operational data with clearly defined breach consequences. You must include testimonial clauses in employment contracts. While you can't prevent someone from testifying if summoned by court, you can require them to inform you before interacting with the authorities unless legally barred. Include a clause prohibiting unauthorized disclosures or cooperation without legal counsel present. You must define conflict of interest and penal consequences. Use employment policies to define acting as a prosecution witness without company clearance as a conflict of interest and cause for dismissal. This sets deterrence, though not enforceable in a court. Now let's understand the behavioral and strategic safeguards. You must conduct internal legal audits regularly. When employees see that legal compliance is institutionalized, not reactive, they are less likely to defect under pressure. There should be transparent communications during investigations. If your company is under investigation, never isolate or threaten employees. Instead, hold legally guided HR meetings to explain rights, duties, and implications of becoming a prosecution witness. You should provide legal counsel access. Offer access to independent legal advice to employees at company's cost. This builds loyalty and prevents panic decisions under ED or CBI pressure. Now, the most important segment of the discussion, what you should never do. Never tamper with evidence or ask anyone to lie. That will convert your compliance issue into an obstruction of justice case. Never intimidate or coerce an employee who has been summoned. Let your lawyer handle the communication. Silence is better than panic. So to sum up, employee loyalty cannot be legislated, but it can be earned, guided, and protected through proper legal frameworks. Draft tight contracts. Educate your people legally. Anticipate vulnerabilities and always consult experienced white collar crime counsel at the first sign of investigation. Because in today's legal climate, prevention is not just better than cure, it's your only shield. This is Dr. Arjun Chowdhury signing off. Stay legally safe, stay one step ahead. Jai Hind.